Welcome to the deep dive. Today we're tackling a really complex subject, involuntary detention, specifically in the context of mental health and intellectual disability.
It's definitely complex. You've got legal issues, ethical questions, deeply personal stories, all tangled together.
Exactly. And for this deep dive, we've gathered quite a range of sources. We're looking at scholarly articles, legal cases, personal accounts too.
That's right. Those firsthand experiences are so crucial for understanding the real impact.
Our mission here is to pull out the key insights. We want to understand the why, the justifications given for detention, the how, the actual processes, and, well, the consequences.
And trying to grasp the nuances, the tensions involved, it's often about balancing individual liberty with perceived needs for care or safety.
Okay, let's dive in then. Where do we start? What are the basic reasons someone might be detained against their will?
Fundamentally, it usually boils down to necessity. The idea is it's necessary for the person's own well-being or for the protection of other people.
Necessity. Okay. Seems straightforward, but I imagine defining necessity or well-being isn't simple.
Not at all. That's where it gets tricky. Whose perspective counts most? What are the objective signs? It's often subjective. And protecting others versus the individual's well-being can sometimes pull in different directions.
Yeah, I can see that. And who makes that initial call? The decision that sets this all in motion?
Typically, it's medically trained practitioners, usually psychiatrists.
Ah, okay. So it's a medical decision primarily.
Well, yes and no. It's often initiated by doctors, but it's not just about ticking off diagnostic criteria. They're meant to consider various factors, the person's circumstances, potential risks, available support. It's broader than just a diagnosis.
Got it. So a diagnosis is key, but not the whole story. Now, I saw in our sources that the bar for detention isn't always the same.
That's right. It differs. Think about civil commitment focused on treatment versus forensic situations where the criminal justice system is involved.
Okay, so the context matters.
Absolutely. And also, whether it's for inpatient care in a hospital, which is obviously highly restrictive, or for treatment in the community, the thresholds are generally higher for forensic cases and inpatient settings. More legal hoops to jump through.
It brings us right to that core conflict, doesn't it?
Yeah.
Individual freedom versus the state stepping in, even if it's meant to be helpful, therapeutic.
Exactly. This tension is central. There's a whole field, therapeutic jurisprudence, that tries to grapple with this, how legal rules and procedures can impact therapeutic outcomes. But even way back, people like Wexler were highlighting this clash between civil liberties and imposing treatment.
It's a long-standing debate. And isn't there a principle about using the minimum necessary intervention?
Yes, the least restrictive principle. The idea is you should only limit someone's autonomy if it's absolutely necessary, and there's no less intrusive way to achieve the needed outcome, like care or safety.
Sounds good in theory. Does it work in practice?
Well, it's enshrined in UN principles and legislation, but our sources suggest it can get sidelined, especially when worries about risk or dangerousness take over. The fear factor can sometimes outweigh the commitment to finding less restrictive options.
So the principle is there, but applying it consistently is the challenge.
Definitely. On the flip side, though, there's a strong argument, again, drawing from therapeutic jurisprudence, that if you are going to detain someone involuntarily for treatment, they should have a legally recognized right to that treatment.
Makes sense. If detention is justified by the need for treatment, you have to provide it.
Precisely. And not providing adequate treatment can actually make things worse, potentially exacerbating the very condition used to justify the detention in the first place.
So the justification itself hinges on actually delivering the help. Are there other ethical arguments used to justify overriding someone's decision?
Yes. Ethicists point to principles like respect for persons, sometimes interpreted as acting in their long-term best interests, even if they disagree now, enhancing their future autonomy, relieving suffering, and, of course, protecting others. Chodoff laid out some of these back in the 80s.
Okay, that gives us a good handle on the why. Let's shift to the how. How does this process actually unfold? You mentioned it varies.
It does vary quite a bit internationally, different countries, different systems, but the common starting point is that assessment by a medical practitioner. They examine the person, consider the factors, and make that initial determination.
But that's not the end of the story, right? There's oversight.
Usually, yes. In many places, there are review processes, special tribunals, or sometimes courts that look at the decision to commit someone involuntarily. It's a safeguard.
A check on the initial medical decision. Our sources mention Freckelton, connecting this to the famous Daniel Schreiber case.
Yeah, it's a fascinating historical link. Sharper's own writings about his involuntary confinement highlighted these enduring questions about rights and review. And interestingly, Dufresne, a psychiatrist, suggested the review process itself, just being heard, could be therapeutic for the patient.
It's an interesting angle, the process having value beyond just the outcome. But these review bodies aren't without criticism, are they? The English mental health review tribunals were mentioned.
Correct. Researchers like Perkins and Frentz have raised questions about how effective the safeguards really are in practice. Frentz's work, talking to both patients and tribunal members, flagged some potential weaknesses.
So what's it actually like for the patient going through one of these tribunal hearings?
Well, often they're held in the hospital itself. You've got a panel, often multidisciplinary, a lawyer, a doctor, a layperson. But you can imagine, for the patient, it can feel quite intimidating. There's an inherent power imbalance.
I can definitely see that. And what are they actually deciding? What's the test for discharge?
In the UK system, which is discussed a fair bit in our sources, the criteria are framed negatively. The tribunal has to be satisfied, the person is not suffering from a mental disorder needing detention, or that treatment is not necessary for health, safety, or protecting others.
Wait, framed negatively. So the default is almost continued detention unless proven otherwise.
That's how some critics, like Hoggett and Jones, see it. They argue it puts an unfair burden on the patient to prove they should be released, rather than the state justifying continued detention.
And does that affect outcomes?
Bartlett's research suggested it might. It showed tribunals relatively infrequently overturn the psychiatrist's recommendations to keep someone detained.
So the system might have a kind of built-in inertia towards maintaining detention.
That's the concern, yes. And beyond the structure, there are communication issues. We saw powerful accounts from patients referenced as patient 12, 19, 10 in one source about feeling not heard, not understood.
Like their perspective wasn't really taken seriously.
Exactly. Feeling dismissed or finding the legal language confusing. It's incredibly disempowering when you feel your voice doesn't count in a decision about your own liberty.
Absolutely. What about the reasons the tribunal gives for its decision?
That's crucial too. They need to give proper reasons that actually engage with the patient's arguments, not just recycle the legal phrases. It shows the case was genuinely considered.
But you mentioned earlier they rely heavily on medical opinion.
They do. And that's challenging because, as one source noted, psychiatric diagnosis and predicting treatment response involves uncertainty. It's not always clear-cut.
So the tribunal is trying to make a legal judgment based on sometimes uncertain medical evidence.
Right. But even if discharge isn't granted, the way reasons are given can matter. Giving oral reasons, acknowledging progress, maybe suggesting the detention won't be indefinite, that can have a positive therapeutic effect. It offers some validation.
Humanizing the process, even in refusal. Okay. Now, there's a concept that seems really central in these discharge decisions: insight.
Ah, yes, insight. It comes up constantly in mental health law, particularly across Commonwealth systems, when deciding about release.
It sounds like it means understanding your own condition.
Broadly, yes. But the problem is, there's no single, clear, agreed-upon definition of insight. And this ambiguity can have massive implications for patients.
How so? How does insight typically connect to discharge decisions?
Often it's linked directly to medication compliance. The thinking in much of the psychiatric literature, and reflected in tribunal decisions, according to researchers like Perkins, is that if a patient has insight, they're more likely to take their medication after discharge.
So lack of insight becomes a reason to refuse discharge because they might not stick to treatment.
Very often, yes. Psychiatrists frequently cite noncompliance or the risk of it linked to poor insight as grounds for opposing release.
But if the definition is fuzzy, how's it assessed?
That's another concern Perkins flagged. How consistently and clearly do tribunal members assess it? Do they have reliable ways to gauge if the patient truly understands their situation, separate from just agreeing with the medical view?
And is lack of insight always deliberate? Like someone refusing to accept reality?
That's a really important question. Some neuropsychological research, like Lysacker's work, suggests that for certain conditions, especially psychotic illnesses, lack of insight might actually be a symptom itself related to cognitive deficits, not just stubbornness.
That changes things dramatically, doesn't it? If it's part of the illness, not just resistance.
It could significantly impact how you view a patient's statements and their potential for future cooperation. It's not necessarily about them being difficult. It might be a genuine neurological psychological issue.
Plus, people might have their own ways of explaining what they're going through, right? Ways that don't fit the standard medical model.
Absolutely. They might use different language, different frameworks to understand their experiences. Dismissing that as simply lack of insight might miss the point entirely.
Are there ways to help people develop insight in the clinical sense?
Yes, some approaches seem promising. McFarlane's work points to things like skills training delivered by clinicians who are empathetic, focusing on the practical benefits of treatment and acknowledging the illness rather than just demanding agreement.
So building trust and focusing on practical outcomes, but courts still worry about it.
They do. Our sources mention judicial concerns, like in the re-PDC case, where worries about insufficient insight affecting future treatment adherence, especially with less supervision, were reasons for caution about release.
Okay, so insight is clearly a major complex factor. Let's broaden out again. Are there different routes into compulsory care besides the standard civil commitment?
Yes, there are choices and overlaps. Sometimes it's a question between criminal prosecution or civil commitment, or looking at things like adult guardianship versus other options.
Like pretrial diversion, what's that?
That's where someone, usually charged with a minor offense where mental disturbance seems a factor, might be diverted into the civil mental health system for commitment and treatment instead of going through the criminal courts.
So treatment instead of prosecution.
For certain cases, yes. It requires good liaison between the prosecutors and mental health services, obviously.
And diversion can happen later, too, at sentencing.
Right. A court might make a hospital order instead of sending someone to prison if they meet the criteria for civil commitment. The RV Back case was an example.
But the court still needs to be in charge.
Exactly. There was a cautionary note in another case, RV Leichels, that courts shouldn't just hand off sentencing decisions to hospitals. It's still the court's job to determine the appropriate response.
Got it. And what about adult guardianship? How does that fit in?
It can be seen as a potentially less restrictive, less stigmatizing option. A court appoints a guardian to make certain decisions for someone who lacks capacity. This might prevent crises that could otherwise lead to involuntary commitment.
A protective measure.
Yes, and places like New Zealand have specific family court processes with safeguards built in when appointing guardians.
Okay. Now, a specific area highlighted in the sources is intellectual disability. This seems to have its own set of complexities regarding involuntary detention.
It really does. There's a strong argument that historically, the way people with intellectual disabilities were institutionalized was effectively involuntary detention, even if not always called that.
And those old ways of thinking still have an influence.
The sources suggest, yes, those historical discourses can still shape current practices and attitudes towards detention for this group.
What are some key concerns today?
A major one is the potential lack of external review. Even with rights-based laws, there might not be the same level of scrutiny for detaining someone with an intellectual disability compared to mental illness.
That's worrying. Less oversight.
Potentially, yes. There are also concerns about guardianship being used, perhaps unintentionally, as a mechanism to achieve detention rather than prevent it.
Using a protective measure for restrictive ends.
And then there was the whole issue highlighted by the Bournewood case in the UK, the idea of de facto detention.
De facto detention.
Yeah, where someone lacks capacity to consent to being somewhere, doesn't object, but isn't free to leave. The House of Lords ruling basically allowed this informal detention without the usual legal safeguards kicking in. It raised huge human rights questions.
That sounds like a legal loophole for detention. Is there anything working in the other direction, helping people get out of restrictive settings?
Yes. Anti-discrimination law can be powerful. The Olmstead case in the U.S. is a key example. It established that unnecessary segregation in institutions is discrimination, upholding the right to live in the community.
Framing it as a rights issue, not just a placement decision.
Exactly. It shifts the focus to integration and community living as a right.
Okay, this is all crucial context. But perhaps the most vital part is the perspective of the people who've actually been through this.
Absolutely critical. Our sources really emphasize listening to these voices. Their lived experience provides insights you just can't get from legal texts or clinical reports.
And what do those accounts tell us?
Some are incredibly harrowing. Descriptions of involuntary commitment involving what felt like violence, abuse, even deceit. Experiences documented in sources like The Myth of Psychiatry.
That's deeply disturbing. It paints a very different picture from therapeutic intervention.
It does. People talk about feeling dehumanized, a sense of their mind and body being separated, controlled by the system, and the impact lasts long after discharge.
How so?
As discussed in Where's the Asylum,
Mm.
people talk about the difficulty of just going back to their old life. The experience changes you, it creates barriers, there's stigma, trauma,
A lasting shadow.
yes, and a feeling of anonymity within the system, a sense that individual needs and desires aren't heard, which leads to calls for mental health consumers, service users to speak up, define what they need, demand change.
To reclaim their voice and agency.
Precisely. To demand a real asylum, genuine safety, effective help. And this perspective also suggests that even the review processes, the tribunals we discussed, can sometimes add to the distress rather than alleviating it.
But so the system designed for oversight can itself be problematic from the patient's view. Okay, let's move to our final area. Community treatment orders, or CTOs. These seem common now, but controversial.
Very much so. Also called outpatient commitment or assisted treatment. It's a major human rights debate. You're mandating treatment while someone lives in the community.
And it's not always a formal court order.
Right. Sometimes treatment is tied to things like welfare benefits, or it might be part of a deal in a criminal case. Less formal, but still coercive in a way.
Does it work? What does the research say about effectiveness?
There is research, like studies by Swartz and Heide, suggesting CTOs can reduce hospital readmissions, arrests, homelessness, even victimization.
What was the mechanism?
Often linked to better medication adherence and reduced substance abuse because there's that structure and monitoring in place.
So, some evidence for positive outcomes, but the core issue of compelling treatment remains.
Absolutely. That's the ethical tightrope. Critics worry about coercion infringing liberty. Proponents argue it might prevent worse outcomes like lengthy hospital stays and ultimately support long-term stability and autonomy. There's even this idea of volunteers for compulsion, people who actually find the structure of the order helpful for staying well.
A complex psychological reaction. How is it handled in places like New Zealand?
Their Mental Health Act actually has a presumption in favor of CTOs over inpatient care where possible. They consider the treatment needed, but also the person's social situation.
And they have flexibility.
Yes, they can bring someone on a CTO back into hospital for a short period if their condition deteriorates without needing a whole new commitment process. It allows for quicker intervention if needed.
Interesting. Are there downsides flagged in the sources besides the liberty concerns?
One major worry is resources. If services are stretched thin, could focusing on mandated community treatment end up displacing voluntary patients? Could it mean less support available for people actively seeking help?
A resource allocation issue. That's a really practical concern.
Mm-hmm.
What about alternatives? Is there anything less coercive?
Assertive community treatment, ACT, is often mentioned. It provides very intensive wraparound support in the community.
Is it as effective as CTOs?
That's the tricky part. There aren't many good studies directly comparing ACT and CTOs when they offer the same intensity of services. So it's hard to say definitively if ACT could fully replace mandatory orders in all cases.
So CTOs remain a really active area of practice and debate.
Right.
Right. Well, we certainly covered a lot of ground, from why people are detained, how it happens, the review process.
The complexities around insight, the different legal pathways, specific issues for intellectual disability.
The absolutely crucial patient perspective, and these ongoing debates about community treatment.
And running through it all is that fundamental tension, isn't it? Between individual rights and autonomy and the societal or clinical drive towards care and safety. Defining capacity, assessing risk, understanding subjective experience, it's incredibly challenging.
And the impact of these decisions is just immense for the individuals involved.
Profound and often lifelong. It really underscores the need to get these frameworks right, or as right as we possibly can.
Which brings us to a final thought, really a question for you, the listener. When you consider all these different viewpoints, the legal arguments, the clinical needs, the ethical dilemmas, the lived experiences, how can we make these systems better?
Yeah, how can legal and clinical practices evolve to be more humane, genuinely effective, and more respectful of autonomy while still meeting the needs for care and safety?
What's our collective responsibility here, especially for those whose liberty is restricted because of mental health challenges or intellectual disability? Something to really think about.
Definitely. We hope this deep dive has given you some useful perspectives. There's always more to learn, and we encourage you to explore the sources if you're interested.
Thanks for joining us for this deep dive. We hope it's provided some valuable insights into what is truly a critical and complex topic.